not snowing up there. They're supposed to be getting this big storm, they're not getting it. Oh, children, come back, please.
I'm gonna leave soon.
Pardon? I know. It's a very, very old jacket. It's cute. Thank you. I'm not carrying. 18 years old. I loved it. I loved it when I bought it. Then I had to have the top.
Okay.
No, I'll go back and get it after this, before we do the charter. Yeah, thank you though. I want sugar too. One more.
I have no idea what she is.
Okay. She's gonna, oh, she has to be here for the hearing, doesn't she? Sorry, folks. Everybody has to be here for a hearing, apparently. Julie, we do all have to be here, right, for the hearing to start?
For the rulemaking hearing?
Mhm.
You should, folks should if they want to vote.
Here we go. State Board of Education will now conduct a public rulemaking hearing for the rules governing standards for individual career and academic plans, ICAP 1 CCR 301-81. The State Board voted to approve notice of rulemaking at its November 8th, 2017 board meeting. A hearing to promulgate these rules was made known through publication of a public notice on November 25th, 2017 through the Colorado Register and by State Board notice on January 3rd, 2018. The State Board is authorized to promulgate these rules pursuant to 22-2-1071C CRS. Commissioner, is staff prepared to provide an overview?
Yes, thank you, Madam Chair. I will turn this over to Misty Roosevin. She's the Executive Director of Student Pathways.
Thank you so much, Commissioner Athas, and good afternoon, everyone. Nice to see you again. So, thank you for your time today, and I just want to make sure and honor your time, knowing that you might be a bit behind in your schedule, that the rules in front of you today are technical in nature, and that this is a rulemaking hearing that is a direct result of House Bill 17-1041 that was passed during this last legislative session. I'm happy to take you through the rules one by one today. Madam Chair, I'll loop back with you after just a couple technical things to remind you of. These rules were circulated widely with educators across our state. We did not receive any public comments during that period from school districts, educators, other folks that these rules are circulated with, et cetera. The notice in front of you, with the exception of one technical change, the staff cot, is the same as what we talked about in November. That one technical change is that the post-secondary and workforce readiness description has changed since you all last updated and adopted these rules. You might remember back in 2016, you updated and adopted the post-secondary workforce readiness description in concert with the Commission on Higher Education, and so that again is purely technical in nature. So with that, Madam Chair, I'm happy to take you through the changes, but since they have not changed substantively, I didn't know if you would wanted me to do that.
Board Member Rankin.
I just have one quick question. Some of these are in red, some are in blue, and some are in, but they all should be the same, I mean in red or whatever. that the colors don't mean anything, correct?
That's correct. Thank you so much, Board Member Rankin. Yes, and we will update our essential skills to try to make it all red next time. Thank you.
Thank you. So we have one individual signed up to speak, Katrina Ruggles.
Hi, my name is Katrina Ruggles. I'm a counselor at the Center School District in the San Luis Valley. I'm also on the board of the Colorado School Counselor Association. I thank you for this time to talk for just a minute about ICAP. I just wanted to give a picture of what ICAP has really meant to our community. My school district is a small district, about 650 kids, K-12, and very high poverty rate, 94% free and reduced lunch rate, about 89% minority population. We started ICAP about 8 years ago, actually, and really have worked to develop a systems approach to career development for our students, really working to engage our community, our parents, our staff, everybody in the process of helping students develop a vision for the future. Many of our students come from very, very difficult situations, and really without a vision or some kind of hope for tomorrow, the decisions that they were making today didn't really matter to them. It was okay to make decisions around drugs and alcohol, violence, sexual decisions that were really impacting their future. And since that time, we've been able to help we've developed a culture where all of our students graduate with some kind of post-secondary plan. In 2004, about 20% of our kids went on to post-secondary education. Last year, about 92% of our kids went on to post-secondary education. So we've had a gradual increase over all of those years. And students are coming back now with degrees, starting businesses. We have 2 students that started technology business, one that started a printing business, et cetera. So it's really not only about changing the culture of our school, but the culture of poverty in our community. And so really I'm just here to say thank you for supporting ICAP and the work that it promotes within our community, because it really is about changing not only what's happening now, making the academics more relevant, more meaningful, and helping our students grow that way, but also really about changing the future of what's going on in our communities and our culture and our economy. Thank you.
Thank you. Congratulations to Center. That's great. Did anyone else want to speak? Okay, we can move on then. So this concludes the rulemaking hearing for the rules. Is there any further discussion or questions? Mr. Durham?
Thank you, Madam Chair. On page, I'm going to work from the red line version, so starting on page 2 of the red line version, 2.00 print 7 is progress in visual and performing arts a statutory requirement as part of the ICAP?
It is.
So whether it's of any value or not, it's still required.
Madam Chair, would you like? So how most districts are looking at that is if a student courses, which will presumably reflect the visual and performing arts, if that's captured in the ICAP, then that's sufficient.
So if they take any courses. If
Right.
they don't, then
Then
there's no
that's-
requirement they take any courses.
Right.
And so 2.01, paren 1, paren C on that same page, the student's progress. Is that progress reporting required by statute?
So both of those are statutory requirements directly, and how districts are looking at that, again, is if the student schedule or transcript is part of their ICAP, then that's sufficient.
All right, and then the one above that, 2.01, paren 1, paren A, documentation of the student's efforts in exploring careers, including written and post-secondary, and so on. Then the last part of that sentence, interest surveys that the students complete in anticipated post-secondary studies. I would presume that documentation of the interest surveys is not required by statute?
So all of the rules and the language, or all the language in the rules is certainly up to interpretation by the school districts. The guidance that we've provided is providing students the opportunity to do these things, and again, their goal, presumably, what is their goal for after?
So not
high school.
required. And I
Right.
think what I'm trying to get at is the problems we've experienced with Naviance and their unwillingness to comply with state law. So I would like to put a period after the word goal and strike the balance of that sentence, and I'll make that motion.
What would that mean?
Well, that means that would mean then just what the sentence said, is a documentation of the student's effort in exploring careers, including a written post-secondary and workforce goal for the student, comma, and yearly benchmarks, insert the word "and" there, for reaching that goal, period. Strike then interest surveys and so on.
You know, may I speak to that?
Board Member Flores?
I think those inventories, like I don't know if we still have the Campbell Strong, aptitude test, but I think those aptitude tests are very important. I know that ETS have Plato, and there are several other inventories that are very helpful, at least in the exploratory, when kids are just exploring what they might want and an aptitude for it. I think they're important, and I just can't see how kids could do without them.
Could we have some clarification whether this was in the law or not?
Yes, I was, Madam AG.
Counselor?
I'm sure you could answer as well, and I was just double checking the statute as well. That language really is straight from the statute. I'm in 22-2-136, sub 2A, and then it has a Roman numeral 1, 2, and 3 that literally sort of are repeated verbatim here. So it is in
Okay.
the statute.
All right, thank you.
Proceed. Is that all?
No,
Okay.
on page 3, 2.01, paren 2, each ICAP shall be accessible to educators, students, parents, legal guardians, and approved post-secondary providers. I'd like to put a period after the word legal guardians. I've heard, as I think many of you have, that and may be shared in compliance with the Federal Family Education Rights and Privacy Act. 2.01, paren 2, and it's red paren A is stricken. That districts are not very good at complying with the Federal Family Rights and Privacy Act, and so at the end of that first line where it says legal guardians may be shared only with the approval of the parent.
It's a guardian.
Right.
The parent has to.
And guardian, I'm sorry.
Oh, okay.
In other words, we know that there are service providers that don't comply with state law on privacy. So another way to skin the cat would be to say service providers that have been certified to meet the requirements of state privacy laws, but I don't think there's adequate protection for parents in here, and I've had a number of complaints about the utilization of these surveys and the willy-nilly sharing of these surveys with people without parental consent. So one way or the other, I'd like to deal with this question.
That's directly from.
Counselor?
Is it? I'm not
It is
seeing
here,
it.
sorry.
Right. Right, I just, okay, all right. As I'm reading the statute, board members, I think it splits the baby a little bit and that it incorporates the reference to FERPA is right in the statute, but that I'm not seeing, and I'm not seeing a reference to this approved post-secondary service providers language in it. So it would appear that that aspect of it could be stricken. I don't know that it matters. I mean, FERPA's FERPA, it applies whether we mention it in the rule or not. So what the statute talks about is just that the public school creates and maintains the ICAPs in compliance with FERPA. So it's just sort of a truism, and in terms of whether it's in the rule or not, I don't think it would have to be.
And if we were to leave FERPA in, there's nothing would prevent us from referencing Representative Lundin's recently passed statute about student privacy.
Yeah, I'd rather put that in.
We could add that in.
I'd rather put that in rather than,
Well, no, both.
pardon?
It would have both.
Yes.
We should have
We could leave
Right.
both. It should be an and rather than an or.
Great, thank you.
Right.
So if we were to reference that
That-
recently passed statute,
Yeah, which is going to be in Article 16,
right,
I believe, yes.
and in compliance with, maybe we could, after the word service providers, we could say who are in compliance with that section as well and add it there.
Great. Thank you.
Okay.
Anything else?
So I'll make that as a motion, that these rules be amended to reflect that.
When we do the motion,
Is it on the table for amendment? Oh, it's
no.
not, okay, all right.
I'm slow.
Then I have to go back, all right. And then, let's see, I may have, I think she's got the language. Okay, let me just take a look. Oh, I just found a redundancy on page 5, 2.02 paren 2, stricken double B.
Sorry, where are you, sir?
We
Page
just got to
5.
5, so you
Oh,
need to
page
now
5.
tell us
I was
where
looking
we're
at
Page
the
5,
of the red line did.
yeah.
2.02 what? 2B.
2B. After the word staff and put a period. I presume that districts know the staff includes administrators, counselors, and teachers.
Well,
Just perhaps too much of a reach. It's just a redundancy.
So in the parens, remove the parens. Okay,
Just remove the parens.
thank you.
And then I do have one other question. Are ICAPs, they start in 9th grade or they start before that?
So in state law, they start in 9th grade, and then some districts voluntarily do it before.
So our rules are applicable only to 9th grade forward?
That's correct.
Okay, thank you. So that's
ninth
it.
grade or 8th grade?
9th,
Even though they start in 8th?
No, they start.
they start in 9th.
Oh, they do, I misunderstood.
They can, apparently, but district could start at 8 if they want.
Correct.
So I'd move is there a motion on approving the rules, and then I'll make the amendment?
Go ahead and make the motion, and we can, if there are other questions, we can. He's- You two make up your minds.
Do you want me to make the motion and
Right,
you put
and-
the amendment, or do you want me to include it in the motion?
Either way.
I can do that.
Yep.
I move to approve the rules governing standards for individual career and academic plans, ICAP 1 CCR 301-81, with the amendment on 2.01 paren 2 regarding the addition of the law passed by Representative Lundin in 2017, amended on 2.01. In addition to that, on page 5, 2.02 paren 2, paren B, strike the very last few words that say including administration, counselors, and teachers because of the redundancy with the word staff that precedes it.
Thank you, Board Member Rankin. That's a proper motion. Is there a second?
I seconded.
Thank you. Board Member Goff.
Well, friendly amendment, hopefully. Rather than mention the representative by name, is there not a bill number that can be?
Yeah,
Just don't.
that's
Yeah.
implied in the motion.
1323.
Thank you.
Is it 15 or 16?
What I'd recommend is we just use the actual statutory citation now, not even the bill number
Exactly.
will work. So that's 22 Article 16 sections. I can't remember how many sections it has. We'll get it in there.
Cool. That's right.
Ms. Cordial, you want to call the vote, please?
Board Member Durham.
Yes.
Board Member Flores.
Yes.
Board Member Goff.
Yes.
Board Member Masnak.
Yes.
Board Member McClellan.
Yes.
Board Member Rankin.
Yes.
Board Member Schroeder.
Yes.
The motion passes 7-0.
That was a lot easier than I thought it was going to be, Steve. See, we're all here for that.
Thank you, folks. Thank you. Is it possible for us to take a 3-minute break to get a cup of coffee before we have an hour and a half?
Yeah, because
Charter
Bridget wants
school.
it.
What about
But
a
please.
10 minutes to walk?
No, no. 3 minutes. Enough time to get a cup of coffee that's been made for us. Please. I know you'd like to go for a walk. I get it.
Being
Maybe it's
what?
raining. Colorado State Board of Education will now conduct a hearing in case number 17 CS06, the appeal of Poudre School District R1 to deny Compass Community Collaborative School charter school application. During this hearing, the board is acting in its capacity to hear appeals of charter schools and will hold an appellate hearing under the relevant charter school appeal law 2230.5108. I'd like to ask the person chosen to represent each party to enter your name in the record along with the party you represent. Please also introduce the persons you have designated to answer questions of board members. Only the individuals identified by the parties have the opportunities to address the board. Council, please introduce yourselves and your designated witnesses.
Thank you, Madam Chair. I'm Tim Farmer, attorney for Compass Community Collaborative School, and briefly, I'd want to make sure the record's corrected. We're not appealing from a denial of the charter school application. It's a unilateral imposition of conditions. Just wanted to clarify.
Okay.
Here with me today is Jan Harrison, co-founder of Compass, Dan Schaller, who is the Director of Governmental Affairs for the League of Charter Schools, Colorado League of Charter Schools, and also Gina Curler, who's the Vice President of the Board of Compass Community Collaborative School, and she's also a prospective parent of the school.
Thank you.
My name's Tom Crabb. I'm Poudre School District's Legal and Policy Counsel, and with me is Dr. Todd Lambert, who is the district's Assistant Superintendent of Elementary Schools, and he also serves as the district's Charter Schools Liaison. And to Todd's right is Dave Montoya, who's the school district's Executive Director of Finance.
Great, thank you. The role of the State Board is to consider only those issues raised in the notice of appeal. The board has been provided with a record on appeal. References to documents or testimony not present in the record of appeal shall not be considered by the board. In relation to those issues contained in the notice of appeal, the board will apply the following standard of review following oral argument. The board will decide whether it is in the best interest of the pupil, school district, or community to support the local board decision to deny Compass Community Collaborative Schools charter school application. I realize our terminology is a little off here. We're kind of staying within statute. We do understand that the charter has not been denied at this point. Does that help? Am I okay, Counselor? Clarifying
Yes, I
that?
mean, what you could just modify where it says deny, say, imposition of conditions.
Imposition of conditions. I'll try to remember that. The parties have already submitted written arguments and information. A maximum of 30 minutes will be granted for the oral argument and examination of each party's issues. You may reserve a portion of the 30 minutes for your rebuttal. During this time, the party may summarize its written argument and information, and board members may ask questions, and we do. The hearing shall proceed as follows. Compass Community Collaborative School, the appellant shall present its arguments, including questions from the State Board. Poudre School District, the appellee, shall present its arguments, including questions from the State Board. The appellant, Compass Community Collaborative School, shall present its rebuttal. Again, the State Board may ask questions. The appellee, Poudre School District, shall present its rebuttal, and State Board may ask questions. After that, the State Board will deliberate and render its decision. We will adhere to the maximum time limit. Each segment will be timed. You'll be notified by Ms. Cordial when you have 5 minutes remaining of your allotted time. Compass Community Collaborative School, you may reserve some of your 30 minutes for your rebuttal. Do you wish to do so, and how much time do you wish to reserve?
Yes, Madam Chair, we wish to reserve 10 minutes for a rebuttal.
Thank you. Likewise, Poudre School District, do you wish to reserve some of your 30 minutes for rebuttal? And if so, how much time would you like to reserve?
Yes, the district would also like to reserve 10 minutes.
Thank you. As is customary with any oral argument in an administrative hearing or judicial proceeding, we anticipate that board members may have questions, and they may interrupt counsel with these questions. This is the only time during the hearing when state board members may question the parties. Board questions and your responses are included in your 30-minute maximum time. Are there any questions from the board or council on our board procedure? All right, we shall now call on Compass Community Collaborative School for an allotted 20 minutes for their initial presentation.
And thank you, Madam Chair. And I want to start by saying it was our genuine hope that we wouldn't have to be here in front of you today. When we first encountered the approval with conditions, we did engage with the district and genuinely hoped to be able to resolve our differences before arriving here. Unfortunately, we were just too far apart, and the district was not flexible enough in its position that we felt that reluctantly we needed to file this appeal to ultimately get the charter school into a position to be able to open this fall with some reasonable assurances. I think it's important as well for me to, because I understand that the argument we're making may get a little bit confused, and I want to make sure that we're very clear about something. We share the district's concerns. We recognize that a charter school can't open if it doesn't have a facility. We recognize that a charter school can't open if it doesn't have an adequate number of enrollment. It can't open without a financially viable budget. We completely agree on all of those points. Where we disagree with the district is the method by which they are trying to ensure that those things occur. We essentially argue that the Charter Schools Act has laid out a process through which a charter school gets approved on the front end, it works out a contract with its authorizer, and then it can meet certain milestones through the contract to eventually be able to open its doors. That the opening of the charter school and the approval of the charter school are two separate events, and unfortunately the district has tried to conflate those two through its resolution. Essentially, the approval resolution adopted by the district allows them to deny our charter application as late as August 15th, 2018, mere days before the school is set to open. Again, what we're not saying is that the charter school shouldn't be allowed to open if it doesn't have a proper facility in that time or financially viable budget. We just think that the way that the district needs to make sure that happens is through the charter contract, not through sort of holding the approval or denial over the head of the charter school. We also aren't arguing that a district can't impose conditions on a charter school. They clearly can in statute, but those conditions aren't limitless. They have to be conditions that conform to the boundaries set by the Charter Schools Act, and part of what we're arguing is that these particular conditions do not. If you look at the Charter Schools Act, there's a 90-day window within which a charter application is submitted and within which it needs to be approved or denied. Then there's a second 90-day window after that occurs for you to negotiate a charter contract. It's essentially a 180-day process that's cleanly and clearly laid out there in statute, after which a charter school emerges as a charter school, ready to go out and contract for a facility, enroll pupils, raise funds, spend CCSP federal dollars if they've received that grant, which the school has. And it needs that reasonable assurance, and that's why the Charter Schools Act provides sort of these boundaries within which an application must be approved or denied. It is not designed to leave a school in limbo up until a few days before it starts. It opens its doors, and actually if we take this position of the district to its conclusion, there's ultimately no boundaries for which they have to eventually say, yes, you're an approved charter school. They could ostensibly say, we're actually going to wait until after the first year that you're open, and then we're going to look at you. And if we don't like what you're doing, we're going to deny your charter application. Now, if that strikes you as illogical, it is, and it's what's happening here. There's a reason why there's that 180-day period, and the district must make up its mind within that 180 days. We also don't think that the district should be allowed, as it's trying to do, to manipulate language in the charter contract to essentially insert conditions precedent that would render the contract ineffective and ultimately the charter application denied if it doesn't meet certain conditions. Just for example, the way that they try and have it designed is essentially saying if you don't have your certificate of occupancy by August 15th, which is that particular condition, we don't work through the charter contract in a dispute resolution process and all of these typical safeguards that are in place to shut your school down. We just pull the rug right out from under you, say your charter's denied. Oh, and by the way, you have a 120-day process with which you can appeal to the state board, as though that's some kind of adequate remedy. At that point, we would argue that it simply isn't. The second piece of the resolution that we think is in violation of the Charter Schools Act is there's a number of provisions that require the charter school to go seek approval from the district's board before it can adopt certain things. So for example, they say that before you can sign your lease, you must come to the district board. The district board gets to review your lease. We may or may not tell you some things that you have to change in it, and then we will tell you you can sign your lease. It says you have to bring your employee handbook to us, and we get to review your employee handbook and determine whether or not it meets, our criteria. And then we will tell you that you can approve your employee handbook. Keep in mind that these aren't the district's employees. They'll be the charter schools employees that these policies will apply to. Let me read you this piece of the Charter Schools Act. A charter school shall be responsible for its own operation, including but not limited to preparation of a budget, contracting for services, facilities, and personnel matters. Does it get any clearer than that? We really think that these conditions are a violation of the charter school's autonomy, over its objections to essentially give permission to the district to micromanage these very important decisions that they're going to be making as an autonomous board. I want to make sure that this isn't confused with us saying that the district doesn't have a role of oversight. It 100% absolutely does. It can review any of these documents that they want to. On one hand, they're a public document, but they can review them. They can provide us feedback. We've expressed that we would be open to their feedback. We would consider their feedback. But ultimately, the final decision, as is stated in statute, rests with the charter school, and the charter school is the one that's going to be held accountable for those decisions, so naturally it should be their decision. One of the things that's important on this point, in its answer brief, the district essentially claims that the reason this statute doesn't apply is because Compass is not a charter school, it's a charter school applicant. Again, it just sort of defies logic that outside of that 180-day window, we're still calling it a charter school applicant. It's going to spend CCSP federal funds as a charter school applicant. It's expecting to go and contract for a facility as a charter school applicant, hire a principal, hire staff, enroll students as a charter school applicant. It just sort of defies logic, the way that the district views the school, again, all the way until August 15th, and ostensibly it could extend that out further. If we don't say here today that the law clearly sets parameters within which you need to approve or deny a charter school. So, again, I just want to emphasize this notion that it's really put Compass in a difficult position. It's almost like a chicken or the egg situation where they're saying, well, we're not going to approve you until you go out and sign a lease or enter into a contract for a facility. We're not going to approve you until you enroll students. We're not going to approve you until you raise a certain amount of funds. We're not going to approve you until you do all of these things. But any responsible school wouldn't do any of those things until it's approved. So it puts it in a really difficult position. Again, we're not seeking guarantees that this school will open up in the fall. Obviously, it needs to open up, it needs to get a facility. Obviously, it needs to enroll students. Obviously, it needs to do all those things. But those things can be addressed through the contract. We've put forward at least one way, and this is sort of the industry norm, the way it's been done in the dozens of charter contracts that I've negotiated before. There's ways to put pre-opening conditions into a charter contract through which, if they don't have a facility, they don't open. But it's a contractual measure. It's not the holding of the approval of the charter application over the head of the charter school, which are very different things. This school wants to go forward. Ostensibly, it's been approved. We recognize that it was approved with conditions, and we want to meet those conditions, but ostensibly it's been approved, and we want to go forward. We want to make commitments to members of our community. We want to make commitments to students and families, but we believe that it would not be in the best interests of those students and families, those pupils, if this school was not given the reasonable assurance that every other charter school in the state typically gets before opening, so that it can go out and start making those decisions and doing those things that it needs to do. To decide otherwise, we argue, would not be in the best interest of the pupils, the district, or the community. And we respectfully request that you remand this case with instructions to the district to remove any language that casts doubt as to whether or not it's a charter school after the contract is signed. Once a contract is signed, it is a charter school, not a charter school applicant. That it not put any language into the contract that casts that into doubt, or these conditions precedent that have been discussed, as well as any language that would require them to forego their statutory autonomy and decision-making authority as discussed over facilities, personnel decisions,
Excuse me,
operations as
Mr.
well.
Farmer.
Yes.
So this question is for you or whoever is best able to answer this question, and I particularly would like Mr. Schaller to weigh in on this too. What is the, what is the plan for your charter governing board? There seems to be a lot of concern that you don't have enough members that would be elected by parents at the school. So what's
Yeah.
the plan? And I'd like
So-
Mr. Schaller to comment on how often this happens with charter schools, or what's usual and normal for charter schools.
I'll start with the board question, as far as the specifics, I'll let Jan respond. But I mean, in the world of charter schools, there's all different ways that boards are designed, right? I mean, you have appointed boards where the board appoints the next members. Sometimes it's half and half. Half are elected by the parents, half are appointed. Sometimes there's requirements around, have to be half have to be parents, majority has to be parents. It's really because, they operate as nonprofit corporations. There's any number of ways that you can elect or appoint a board of directors.
So what's your thinking on, what's the plan for this board?
Good afternoon. Thank you for hearing our case. Our plan, as we wrote it in the charter application, was to have one board member be elected by the parents and the rest be appointed members of the community to bring expertise.
How many board members total?
Between 5 and 9.
Okay.
What,
And do you
5 and
plan to
11?
have it that way into perpetuity?
That's, I don't think, I don't want to say we're going to do anything in perpetuity.
But you don't have any plans to change that after 2 years or 3 years?
There isn't a current plan to change that after 2 or 3
And explain to me
years.
why you would only have one member.
Our model as a community collaborative, it's very important for us to have connections to the community, including opportunities for students to have internships it was interesting to hear the ICAP discussion earlier, and just that idea of having people who are in the community working and know what they're looking for as employers to be helping guide our school and make sure that we are fulfilling and producing students and helping students develop the skills that are needed for the workforce and college readiness. So we felt like to be able to, it doesn't mean that they wouldn't be parents or that they wouldn't be.
That was my next question, is
Right.
how many of those members of the board who have the expertise you're looking for but might also qualify as parents?
Any might,
Any?
yeah.
Can
What about your founding board? Yeah, where are
Can I
you?
just jump in as an appointed parent? There's nothing stopping us from appointing parents. So, of course, this isn't mutually exclusive. The one elected position is just to ensure we have one elected parent that's at large.
And your focus is on the expertise of board members.
Exactly.
And Mr. Schaller.
And the community that they represent.
Okay.
Yeah.
And Mr. Schaller, would you comment on how rogue or normal or, this is for charter schools?
Yes.
As far as how they design and make up their boards?
Yes, and thank you all. Again, my name is Dan Schaller. I'm Director of Governmental Affairs with the League. I would just echo what Tim said, that there are various arrangements that different charter schools construct in conjunction with their districts around what the makeup of that board should be. I would say that oftentimes there is parent representation, much like Compass Community is intentionally injecting into the construction of their board. So generally speaking, I would say that there's often parent involvement.
And what would be your opinion on what statute says about a charter's ability to design their board?
Yeah, I think it's a great question, and I think I'll step back just real quickly and speak briefly to why I'm here today. Because the League is traditionally very judicious about which of these appeals processes that we get publicly involved in. And I think the two criteria that we're generally looking at are the worthiness of the applicant. And in this case, Compass Community went through our extensive review process and came out on the other side with a very strong application and a very strong referral from our new schools department in terms of the quality of their application. But then maybe more to the point of this particular situation, the other thing we look at is whether something has ramifications and implications for the charter school sector at large. And in this particular situation, our concern is that some of the conditions that are put into the resolution are overreach, that they fundamentally kind of cross that line between what a charter school is. Going back to the creation of charter schools 25 years ago, it was autonomy over the inputs in exchange for accountability on the outputs. And things like trying to dictate what the employee handbook needs to include, or trying to dictate what the internship program needs to entail, potentially even questions about the board construction. These are things that are starting to get into the actual management of the school as opposed to the oversight role that the district should play.
Board Member Flores.
Yes, but Mr. Schuyler, do you know if Poudre School District has rules on particular rules for their district that concern parents on the board? Are you aware, or maybe you want to answer that? I mean, certain school districts have particular rules about how many parents should serve on their board, and that's something I think that's important. And before you answer that,
yes, ma'am.
maybe we don't have very much time, and I wanted to ask you too about just how you go about this. I mean, I served on an accountability council for Denver Public Schools, and those questions that they're asking you, those questions are up front from the very beginning. That's what an accountability council has, and I'm sure all those questions. It's important that the district know that that the kids are going to be in safe hands, and that that you have a viable plan, that you are going to have so many students, and that's something that is looked over by committees, not only by the board but other committees in the school district, so that the kids' health and
Sure.
and their academic.
Let me answer, right?
Yeah.
Well,
Let me answer.
well, I haven't finished yet.
I do understand the question.
Well, the question is, I mean, I looked at it and I saw it as a quibble. Why wouldn't you want to, at the very beginning when you have these questions, sit down with the district and just discuss it?
Yes, ma'am.
Why didn't you do that? I mean, because this is...
So we did, and the answer to your first question about the board, I do think that is a subject of negotiations. I don't think that a district should have inflexible rules of, say, every charter board in this district must have a board that looks like this. But I've sat down
they
in
might
many,
have particular, not all.
as long as it's part of a give and take in a negotiation process, I think every school is open to, you want us to have two parents on our board, that's fine, let's negotiate how we want to do this. And to your second question about making sure the school's safe, making sure that they have a proper facility, all those things, to me, those are controlled through the contract, not the approval process, but through the contract.
Okay, so in the contract, why, you did have this at the very beginning, and I was assured by our counselor that you indeed had this at the very beginning. You had these conditions.
Mm-hmm.
So why didn't you try to sit down immediately and negotiate?
We did quite a bit. The district informed us that the language of the resolution would not change one word, and when we said, can we maybe modify the way it's incorporated into the contract, we were told no. That's what prompted the appeal.
So could I ask a question, please, on the resolution area 3, or condition 3?
Yes, ma'am.
From what I can tell, Compass only has a concern with item F, which is that the request by the district is that the majority of the electors of the board be members of the community, school community. But I want to clarify, the other A through E are items with which, and G are items with which you agree, as long as they are items that are in the contract as opposed to. So I want to clarify F. When we're getting in this discussion, we mix up the notion that the board has to have X number of parents versus the opportunity for more than half of the board members to be elected by parents, which can very well mean that some of the criteria that you have for board members representing different folks in the community can still be expected, but that the voice in terms of electing the board members at least half or a little bit more than half would be parents. To me, those are two different things. I've looked at your chart where you're looking for different characteristics of board members. I get that, and I think there's a good way to do that. I think the concern that we have is that you only have one board member elected by parents. So I'd like to continue that discussion next time around.
Yeah, and I would say if that one that you highlighted, if that was the only dispute we had with the district, in all honesty, we probably wouldn't be sitting here today. It's sort of the totality is what's led and prompted this appeal.
Okay.
We're confident we probably could have negotiated around the stuff.
Okay. Thank you. We'll listen to you again in a few minutes, 20
Yes, ma'am.
minutes as a matter of fact. Pooter, please.
Thank you, members of the State Board. Needless to say, much of what Mr. Farmer has said the district disagrees with. And in large part, the district disagrees with things that can be demonstrated in the record on appeal, and I'd like to step through that and cite to the record where we disagree and why we disagree. But before I do that, I want to set some context here. It is true that the district approved this charter application. The district didn't deny it. They approved it with conditions. And those conditions are in there to ensure that the school succeeds. The district, the Board of Education, and every member of the administration wants to ensure that the school succeeds. And at base, one of the reasons for that, the prime reason for that, is something that Director Pedersen on the district's board said when this was being approved, which is at the end of the day, all of the school boards, all of the Pooter board's actions are for the benefit of the students to ensure that that will accrue to their benefit.
Mr. Crabb?
Yes.
There are 4 other charter schools in Pooter Valley, is that correct?
Correct.
So if I were to call some of the previous founders and ask them if there were a condition in their initial approval that said it would be deemed denied if X and Y wasn't happening, they would all tell me yes, is that correct?
We have 4 schools, 2 of them were approved before I had any association with the district.
So if I called Bob Schaefer and I said, this was the condition of your approved school, he'd tell me yes.
That was one that was approved back in the 1990s, so no. But
So it managed to survive without this automatic revocation of the charter as a condition, and yet you think this condition is necessary for this particular charter school?
Well, if I could explain the conditions, I guess I'm not sure I understand what's behind the question, but I don't agree with Mr. Farmer's characterization that the district's resolution works the way he says, and that the district hasn't attempted to negotiate.
I'm open to be persuaded, but plain language says it's deemed denied if X doesn't happen, so go ahead.
If you look at the resolution and turn to, this is document number 7 in the record on appeal, and if you turn to paragraph 3, which Dr. Schroeder referenced earlier, the first part of paragraph 3 says that Compass shall negotiate and sign a charter school contract that is mutually acceptable to the board and Compass. Item number A there says that the first thing that the district and Compass need to do is to negotiate and sign a mutually agreeable contract. At the end of that same paragraph, item number G, it states that the terms that are in the resolution that haven't been come up time-wise yet will be incorporated into the contract. So the contract terms include the provisions of the resolution that are incorporated in there, and they are subject to resolution or to negotiation. And if there's questions, for example, on when it works for Compass to show that they have sufficient students enrolled, if May 16th doesn't work and they want to talk about another time, that's something that can be done.
Well, have you refused to remove the automatic revocation language which is at issue.
We haven't had a chance to negotiate about it. If I can.
Did you say you wouldn't remove the automatic revocation
No, sir.
notice?
No, sir.
Are you willing to remove it?
We're willing to negotiate over it.
Are you willing to remove it?
We're willing to negotiate over it. It
So you're willing
depends.
to go give and take over something that may be contrary to state law?
It's not contrary to state law.
We'll
What-
see.
What we did also that I'd like to point out is item number 43 in the record on appeal is a proposed form of agreement, which I emailed to Mr. Farmer on December 7th, over a month ago. And within the first section of there is this is a draft proposed form of agreement, which includes the conditions that have not come up time-wise yet that are subject to negotiation. I also talked to Mr. Farmer on the phone on November 29th before I sent this after a board meeting, and the board had asked me to assure Mr. Farmer that the Board of Education was willing to approach this in a flexible, open-minded, and reasonable manner, both in terms of interpreting the conditions as well as negotiating the agreement. But at the end of the day, something that apparently we do disagree with and the Poudre Board stands firm on is that determining whether the conditions are met is something that the Poudre Board has not only the constitutional authority for, but also the authority under the Charter Schools Act to determine whether those conditions have been met. And if Compass would believe that the Poudre Board made an improper decision in some fashion in enforcing those conditions, that the remedy is to appeal to the state board. But right now, what the appeal is about is concern.
Did you have that language in the last charter school that you approved of? How many of your charter schools do have that language?
The most recent two, Mountain Sage and Fort Collins Montessori School. And in fact, Ms. Harrison asked the district, because if you look at the resolution, it says that the form of contract should be similar to the district's other contracts. All of our 4 charters have similar contract language, but these conditions precedent, before the charter has satisfied the conditions, were in Mountain Sage's and Fort Collins Montessori's, and Fort Collins Montessori's contracts.
But what about their argument that by statute, your remedy is not to deem the charter denied, but rather to go into dispute resolution with the charter, rather than, I mean, you're saying that, it seems like sort of a tipped scale here, where you say to them, if you don't like it, you can go to the state board and appeal it. But on the other hand, you're telling them if they don't like, or if you don't like it, your charter is deemed denied. And you don't see that at all as outside of state law?
No, I don't.
No, I mean, up to August 14th, when you approved the charter, that you could, if you didn't like the facilities agreement, that you could actually deny the charter when students are ready and signed up to go to school?
Well,
that would be legal?
I guess that what I would say is that that's in effect a distinction without a difference, because if, as Mr. Farmer is suggesting, he hasn't in either his briefs or his argument here gone into detail as to how this would work, but let's just say there's a contract term that says you have to have a suitable facility in time for the school to open in the fall, and they don't.
But what does suitable mean to you?
Well, we have defined as best we can in the
safety, health
resolution as basically meeting
safe
fire
facility,
codes,
right.
building codes, basic things like that. Something that's important.
If they get a CO, is that evidence of that?
Pardon me?
If they get a certificate of occupancy, is that evidence of meeting?
Absolutely. That's not only what this says, but that's what we've done in the past. And one other thing.
Ms. Masnick's question was a yes or no. You could get to August 14th and deem the charter to be denied if you didn't like something.
Yes.
Is that correct or not?
That's correct.
And that's
but that-
outside the dispute resolution mechanism that she mentioned, that you, even though you may have a dispute resolution method within the contract that you've negotiated, you can ignore that and deem it denied. So you have two remedies.
You could have a dispute resolution mechanism, even if it's just a breach of contract. The point that I'm trying to make is that if they haven't satisfied the conditions, maybe they don't have sufficient enrollment, whatever it is.
But if they say they have and you claim they haven't, then you have a dispute resolution mechanism. If you have a deemed denied provision, then you're done.
They have to show
We just
proof.
deem you denied and we're done here. So why do you need both? You certainly shouldn't need both. And the more appropriate remedy in a contract is a dispute resolution method. Because the ability of the school to appeal to this board, long after the students have all had to go someplace and they haven't been able to honor their contracts with their employees, all that doesn't seem to bother you at all.
I don't know about bothering me or not, but what I'm saying is that regardless of whether you couch it in terms of a charter being deemed denied or them being in a breach of contract, in either case, the school can't open and there's going to have to be some form of dispute resolution to resolve that. Either way.
They may be able to open, and you may end up resolving that dispute resolution in court, if that's, or with an arbitrator, or there are all kinds of ways they could still open if they had a CO, but you still somehow wanted to deem it inadequate, or if you, for some reason, didn't like some language in the handbook, to which to me is the, is the micromanagement, ultimate micromanagement that you got in this thing. But so you don't like the handbook.
But Steve, let me just say this. I mean, this is working in bad faith. Mr.
Yeah, I'll
Crabb,
agree with that.
Mr. Crabb did say that he called Mr. Farmer in November and tried and told him about the resolutions that had to be done.
I'm sure Mr. Farmer will address that as rebuttal.
Well, I hope he does.
Let him address it in the rebuttal.
But I want to hear again from Mr. Crabb. So you called him about the resolutions, and had some of the resolutions already passed the dateline, the timeline?
No, one of them was approaching. I talked to him on November 28th and then again on November 29th. The deadline that was approaching was for them to show that they, in effect, had the $1 million gift that they said they did, which basically drives their budget and everything else they're doing. That's why it was the first one. And what I told him was that the Board of Education isn't going to play gotcha, that we're trying to make sure that this works and we're trying to ensure that it does. And in fact, what we did, even though they made representations that they had the money, no strings attached, and that all that they had to have was an approved charter, and it was approved on November 14th, it turned out that they didn't have the money. And so what the Board of Education did was look at the fact that a prior budget...
But they don't have a charter until they have a charter contract, correct?
No, let him finish,
No.
please.
That's correct. That's why we put... They don't have a charter school until then. Their charter school was approved pending the satisfaction
But I
of
mean,
these
legally,
conditions.
from a legal basis, they don't have a school until they have a contract.
Exactly, which is why I
A
said...
resolution doesn't give them the ability to hire or contract for services or rent a facility.
Actually, that's not accurate. Many charter schools have already formed as nonprofit corporations, and they do employ people before their charter is actually approved. But in this case...
But a lot of entities will not allow them to contract or rent or whatever without the actual charter contract.
Some will, some won't. That's why I sent the contract to Mr. Farmer on December 7th to get the process going so that we could get a signed contract that not only had all the other terms and conditions of employment, but also, most importantly, these conditions incorporated into the contract, and that would have been a subject to negotiation. But I do want to emphasize, I think, two things that are problematic here. One is the assumption that the Poudre Board moving forward is going to act in bad faith. there's absolutely no indication that anyone on the staff or on the Board of Education has done anything other than act in a supportive fashion.
And I would agree with that, but are you really standing behind the notion that you would not remove that language deemed denied?
No.
You're not willing to remove that?
I'm
but-
not saying that, but what I'm not doing here, I don't have authority to speak on behalf of the board and negotiate the charter school contract right here with you
Understood.
people. What I have said to Mr. Farmer, and I will say it to you, is the district is approaching this in an open-minded, flexible, and reasonable fashion. And quite frankly, I think that there's a lot more, a mountain has been made out of a molehill on this deemed denied or anything. This has never been a problem in my experience, and I've been practicing for 33 years. And I've never had this problem before, and we didn't have it with our first 2 charters. If this is such a big problem with this charter school, frankly, that's something that I think can and should be negotiated out, but it has been over a month since Mr. Farmer had this contract, and we haven't heard any response. And something about the micromanaging comments on those conditions, I think, is completely unfounded. If you read these conditions, all they're asking the charter school to do is to cover the base. It's not saying how they have to cover the base. For example, saying an economically viable budget, we're not telling them how to apportion their money. We're simply saying you need to have a budget that has the right PPR numbers and adds up. Same thing with a facility. We're not telling them what size rooms they have to have, where it has to be located, or anything else. We're just saying it has to meet basic legal requirements and safety requirements for the students, but
With all due respect, I would tell you this, that I completely believe you when you say that you're not looking to micromanage. The language of your contract does make it look like it's leaning that direction, where you say you just want this, but the language makes it look a little more heavy-handed than that, so.
But even if it's heavy-handed, it's on the side of kids. It's for kids. And I think a school district needs to ask reasonable. And I don't think any of these questions that they ask are unreasonable. And in fact, I mean, even the board, I told you about the accountability board that I was on for Denver. Those were the exact questions. We wanted to see, first of all, I can't believe that they approved it without having how much it was going to cost and all that. And I would want to see the curriculum. I would want to see lots more stuff than that. And that was at a level that was lower, and we were going to give advice to the board. So, I mean, he is within his right. This district is within their right to ask all these questions. And I think that I have to say it, that you guys, by not trying to sit down and negotiate and coming to the board for something that is, well, I consider a quibble. It's quibbling. And you should have sat down with the board and you should have negotiated this instead of taking what you thought was the high road and come to this board and take our time like this. You could have negotiated. I'm sorry. And I think that they have every right to ask you those questions and for you to give that information to them. I'm sorry, but that's how I see it.
Are we ready for rebuttal, or?
There's been some, if I have a little bit more time, there has been comments made about the lawfulness of this. I'd like to comment on the fact that Mr. Farmer's argument about the lawfulness, or about the unlawfulness of the Poudre Board's unilateral imposition of conditions is based on one sentence out of the Charter Schools Act. And again, I'll read it. It says, "A charter school shall be responsible for its own operation, including but not limited to preparation of a budget, contracting for services, facilities, and personnel matters." The plain language of that says does not say what Mr. Farmer says. Responsibility for a charter school's operations is not the same thing as authority to determine whether a charter school can open, especially when there's another section in the Charter Schools Act that says this. 2230.5107 sub 5 states that a school district may unilaterally impose conditions on a charter applicant or on a charter school through adoption of a resolution of the local Board of Education of the school district. It goes on to say exactly what I said earlier, which is if a charter applicant or an existing charter school disagrees with those unilaterally imposed conditions, the remedy is to appeal to the state board. In terms of the conditions that this Poudre board has put on the charter.
Let me read the condition. If it's not micromanagement, I'm sure somebody will enlighten us, but CCCS shall submit to the district on or before May 16th at 4 p.m. for board consideration an employee handbook that is appropriately aligned with the charter school application with the governing law. I presume that the board gets to determine whether it is appropriately aligned, and the remedy is not any further negotiation or discussion or any of that. The remedy is that it's deemed denied.
That's not true. If you look at the section 10, it says, and the district did this when they weren't able to satisfy the receipt of the $1 million, it says the board may adjust any of the timelines or other terms and conditions set forth in those sections.
Or they may not.
That's right, but
That's
once
right.
again, the board has a discretion. It's its constitutional and statutory obligation to make those decisions, and saying that because they might make a bad decision or an unfair decision that they shouldn't have the decision-making authority all, I respectfully say is just incorrect.
They should be made in around a contract, not in a deemed denial
Which is
method.
what we were trying to negotiate, and that language is included in a document number 43 for negotiation. And as I said before, given all the hullabaloo about the deemed denied, that isn't the point here. The point is if they haven't satisfied the conditions, this dog won't hunt. This school can't work. And that's bad for kids, and that's all we want to ensure is that the students get a appropriate school, an appropriate program, and that's what the conditions are designed to satisfy.
Thank you. Okay. This time, I think we need to have the rebuttal, and if a board member has a question of Mr. Farmer, that's fine, because you can interrupt any time, as I have done. Yep, Mr. Farmer?
It's all right to ask a question now.
Well, it's gonna, what about his time?
That's the way it works, kids.
With apology, I'm trying to get a handle on how atypical this language is. I am the newest board member here, so I have only sat in on 2 appeals so far for charter applications. So given that Mr. Schaller is here with the message that this is going to have implications, I'm getting the impression that your assertion may be that this is atypical language with respect to the deemed denied, and I'm trying to get a feel for whether this is groundbreaking and truly atypical.
Yes, thank you. It is. I mean, to Mr. Farmer's point, there are often conversations around certain conditions that are a function of like the pre-opening of the school, but to have the language around the deemed denial creates a poison pill in that resolution that doesn't create the level playing field that would result out of a contract negotiation situation. And so I think that is what's the fundamental question here. With all due respect to Mr. Crabb, it's definitely a distinction with an important difference in that one, it creates a poison pill that can result in a denial as opposed to a negotiation and a
So
conversation.
is it illegal? Are school boards doing something that's not legal here, or is it just a source of frustration?
I would argue that it is unless we agree to it. I mean, we can mutually agree to virtually anything under the sun, but what we're saying here is that we're not willing to mutually agree to this. So to have it forced upon us.
The conditions that are being placed on new charters that talk about budget and facility and enrollment, are not subject to negotiation. They are expectations.
And let me
that are
caveat.
to protect
And let me
our-
caveat.
to
If it's
protect
outside
kids.
of that 180-day window, if it extends the ability to approve or deny the application outside of that 180-day window, it is outside the bounds of the Charter Schools Act.
So what would have been an appropriate way to put those limitations in the resolution without?
The way that it's done in the Colorado Department of Education's model contract and the way that I've seen it done in literally dozens of other charter contracts, I think in every single charter contract I've ever worked on, is you have pre-opening conditions that become an attachment to the charter contract. They can list every single one of these in there. Here's the key difference, to Mr. Durham's point. If the district decides we haven't met a condition, they can unilaterally just pull the rug out from under us and say, you're deemed denied, see you later, you're done. Whereas if it's worked into the contract, there's an opportunity to cure, a 7-day cure period. There's dispute resolution within which we have to meet with the superintendent and have conversations and try and work through our problems. And then there's also a mediation provision through which if we can't resolve it then we go to mediation and then eventually we would land before this body.
So
So
in
there's
order to-
steps. It doesn't give them all the power. There's steps,
Right,
and we
but
work together and we
In
collaborate.
order to make sure, I mean, the intent of the school board is to protect the kids.
Correct.
To ensure that when the kids come in August, those limitations have been met. Therefore, in establishing the contract, you would have to put in deadlines that allow for all those things that you just described, and I don't know what the total time period is. But that does have that effect then, right? So that you can't say the contract must be fulfilled
Correct.
on August 15th. The contract probably has to be fulfilled
Before that.
2 months
and-
before.
Correct. And another key distinction that started to be talked about, and I specifically proposed this to Mr. Crabb, and he said that they would not do this. We want to make them objective measures. We either have a certificate of occupancy or we don't. If you look at the language of the resolution, it always leaves discretion to the board. We could come with a certificate of occupancy on August 14th, and they could say, it looks like a forgery to me, and in their own discretion, just decide not to do it. What we want to do is change some of the language so that it's objective.
So
We either
you-
meet the requirement or we don't. We have 180-enrolled kids or we don't. We have a certificate of
And you-
occupancy or we don't. Take the discretionary language that they've put in here out.
And do you agree with all of those requirements as reasonable requirements, that you have a facilities lease, that you have the, that's
Not
not
only
the
that, I think there's
disagreement.
probably
The
more.
disagreement is their ability to have too much discretion in denying it and also in the deemed denied language outside of.
Correct. The opening conditions become part of the contract, not the approval process. They are different. They become part of the contract and part of what is required to be met before the school can open its doors and let kids in. That's different than approving a charter
Mr.
contract.
Scheller, is that your, I mean, do you agree with that distinctions that the requirements are not at issue for charter schools in general? It's just the way it was.
Yes.
What was that?
It's time up. Or you have-
No, she said
Oh, no.
5 minutes.
Oh, I thought 5 minutes.
So you agree with that?
I do. I mean, I said before, I think certain things that are starting to verge into the territory of the details of employee handbooks and the details of the internship program do start to get into the fundamental autonomy of charter schools. But the key issue here is the fact that the application, the approval could be deemed denied and pull the rug out from under the conversation is the key issue.
And I take it you are here because you're concerned about this kind of language or these kinds of requirements for charter schools across the state. It has to do with principles for charter schools in general?
That is correct. The 90-day contract,
Yeah,
statutory language around the contract is the key issue at stake
Right.
here.
What's
But
your
this is-
estimate, Mr. Farmer, on how long it would take to determine whether kids can show up in a school if in fact the items have, the requirements have not been met? In other words, how far do you have to back up a contract? Have you ever looked at that in order to make sure that all the remedies that are available under a contract are actually experienced?
So again, it would be couched, so particularly with the certificate of occupancy, which I think you're referencing, it'd be couched in objective language, so we either have it or we
Right.
don't. And so
Right.
really, the dispute resolution would be very quick and swift. We either have it or we don't.
Yeah.
But what we're simply saying is that it removes the discretion for somebody to say, we could hold it in our hand and they could say, we don't see it. And that's basically what this allows them to do.
Right.
I know they're
Right.
saying, trust us, we won't do that. I'm saying put it in writing. Why is it so hard to put it in writing?
Right, no, I think I understand basically what you're talking about. I'm trying to figure out, how does the board ensure that by August 15th or whatever the starting date is, that all things are in place, or there has been sufficient time for remedies, mediation, the items that you just described to me? So you're saying, I think they depend on which particular limitation has or has not been met. Is that
Yes,
right?
ma'am. And it would be subject to negotiation is typically the way it happens. I mean, some people can commit, yeah, we'll have our certificate of occupancy by July 1st. Some sit down with their contractor and it's going to be July 31st. So it's hard to sort of blanketly say this is the standard way that it's always going to be done. It's subject to negotiation, couched in objective fact, and always subject to dispute resolution if there's a disagreement.
Mr. Farmer, I don't think I've ever heard anything like what you guys are doing. I think you should have started immediately on getting those resolutions and
Yeah,
meeting those needs. I think if you want to set some kind of standard, I don't think I'm taking it as this is going to be. We've had different kinds of people who come to us. And I think, first of all, I mean, I call it quibbling.
I can assure you, Dr. Flores, if there was any chance for us to negotiate with this district, we would not be here. It's not inexpensive for them to bring an appeal.
Why would they want to have an appeal?
We
These
don't.
people.
That's what we're trying to tell you. We tried everything we possibly could, and then reluctantly filed.
Well,
and if you
no,
read
but
our
you're going.
briefs,
You're
we implore the district in those briefs to come to the
this
table.
business of it's going to be denied that you're not thinking that it's
Dr.
already
Flores,
been approved.
Dr. Flores, we're going to get to vote on this, so it's not going to help.
Well,
us.
no.
we
I
don't-
mean,
we want to
I
negotiate with
just
the
want to understand
district.
why we're at this point. I mean, they
We are
should have
because
been.
we are. We
Well,
are because we
I don't
are,
want-
and let's
and
let
I don't-
folks speak.
Well, one of the things is, I hope that districts are listening, and I think
Dr.
that.
Flores, you're taking up time for
Well, I
questions.
know, I have to
You
finish.
can say whatever you
Well,
want to
I
when you
will.
vote.
I will, and I want to. Please, just give me the opportunity to do this. I don't think that this should be coming up before the board. This should be had done before.
Thank you,
Should
Dr.
have been
Flores.
done before.
Thank you, Dr.
And
Flores. Do you have any time
you are
left?
so
I'm sorry.
rude, seriously.
Can I make a 20-second closing statement?
Please,
at least?
under the circumstance. 25, you've got.
25.
Okay, so again, this school wants to go out and make commitments to our community. We want them to go out and make commitments to the pupils, to our staff, the people that we plan to hire. We want to open a school this fall. All we're looking for is a level playing field with the district and a reasonable assurance that we can do so, that we can be beyond the charter application and approval phase and into the charter application contract phase so that we can do all the things we need to do to open up the charter school. We respectfully request you remand this case with instructions of the district to remove any language from the charter contract that would treat Compass as anything other than a fully approved charter school once it's signed, and that would not require Compass to forego its statutory authority to make decisions. Thank you.
There's
Thank you.
two legal issues that I wasn't able to get to earlier that I'd like to point out, and these both come from State Board of Education regulations. And these were two of the guiding principles that the Poudre Board used in the conditions in its resolution and in its charter school contract. The first one is that the State Board regulations state that the Poudre Board should, and I'm quoting here, state reasonable pre-opening requirements or conditions for new schools to ensure that they meet all health, safety, and other legal requirements prior to opening and are prepared to open smoothly. In terms of when those conditions have to be met, it would be completely unfair to Compass and unreasonable for the district to say, for example, that they had to have the students enrolled before late in the spring, and the State Board regulations reflect that. They state that the Poudre Board should allow sufficient time for each stage of the school pre-opening process to be carried out with quality and integrity. In other words, just this past Thursday, January 4th, Ms. Harrison called Dr. Lambert and met with Dr. Lambert and the Executive Director of Operations, Pete Hall, about a prospective site that they had just located. And even though this appeal is on, these people came out and met with them, and she was asking, okay, what is the timeline gonna be for getting this thing ready? And working backwards, it came to pretty close to what we had in our resolution, the conditions. Those are basically a guideline, a starting point based on the school district's experience. And as I said before, that same language is included in the contract, and it's subject to negotiation if they don't like the date or think that that's unreasonable.
I thought you didn't have a contract. Now I'm really confused. Are you saying in the did you mean in the resolution?
No, what I'm saying, what I said earlier was that the resolution says that the parties have to sign a contract, and that the contract will include the conditions that are in the resolution that hadn't been met yet. That includes the conditions concerning the facility, and those conditions are contained in the draft contract that I sent to Mr. Farmer, including the date that they have to have the certificate of occupancy, they have to meet the fire code, things like that. I would like to say that it's a bit of a red herring to suggest that all terms and conditions can be objective, so it's like a computer can say if it's been satisfied or not. How do you determine whether a budget is economically viable? There's lots of discretion that goes into something like that, and more importantly, at the end of the day, if there's disagreement over that, I will reassert that I think that it's the local board's obligation to make the call as to whether that school can open. Now, is this language atypical? We have a representative of charter schools here saying that it is. As I said, I've been practicing for 33 years, and I was practicing when the Charter Schools Act was adopted in 1993. And for myself and for the different firms that I work with, and I worked in private practice for 20 years before I came in council here, this is pretty typical language. I don't think that what's important is arguing about what's typical or not. I think Dr. Schroeder asked the appropriate question, is the language lawful? And especially since we're saying we're going to incorporate it into the charter school contract, which is subject to negotiation.
You're saying you're going to incorporate the deemed denied language into the contract. Is that what you just said?
That's what it's drafted now, yes.
So that's not negotiable?
No, I said that it is negotiable. I've said that several times here.
But you've already incorporated it into your contract.
It's a proposed draft. It's
so
the starting
what do they
point
have
for
to give up to get rid of it?
I don't know that they have to give up anything. We haven't done it. We haven't had the opportunity to negotiate yet.
Well, there are a lot of ways to kill a charter school. One of which is to create enough uncertainty in the minds of the people who might give a grant, the people who might lend or lease them a building, the parents who might want to enroll their children in the school. If you can create that level of uncertainty, you can defeat just virtually any charter school. So if you're really serious about trying to promote some opportunity for students to choose and for parents to choose what's best for their own student, one would hope you would be trying to remove as much of that doubt as possible, and a good faith negotiation would remove those doubts so that parents would have some, if they're going to commit to attending the school, they would have a reasonable belief that it might open. If a donor is going to give them $1 million, they would have a reasonable belief that at the last minute, the charter might not deem to be denied. And until I think, and if those provisions are not removed from the contract, I think the barriers to opening are almost insurmountable.
And yet we've had 2 charter schools with that exact same language
Congratulations.
that have opened.
Did they have $1 million grant?
Because, no, they didn't.
They didn't.
As a matter of fact. And that, because
maybe to get $1 million, you have to have a little more certainty.
The board acted in good faith with those charters just as it will with this charter and just as it has up to this point with this charter. Something that's a problem with, again, I was emphasizing this before, Mr. Farmer is saying instead of denying the charter before it opens, that it should be in contract language that says you go to a resolution process, and then he listed a couple other things. By that point, you're into the fall semester and you have students, you talk about uncertainty, you have students and parents and staff members who don't know whether the school's going to be able to exist or not because these things haven't been satisfied. Again, the purpose of the conditions is to help the charter and to draw reasonable timelines to say if you haven't crossed this, if you haven't covered this base by this time, the charter won't be able to open in the best interest of the students. That's the reason for that, and the Board of Education has to make that call. We also had a charter school before which by its own terms, it agreed it wasn't able to locate a site. What this board did was to continue to work with them, and they were able to open in a subsequent year. That's Mountain Sage. So this is something, this idea, this assumption that this board is going to act in bad faith, certainly they could, but there's absolutely no indication that they have, and the language of this, that it's been administered by the board, shows that they haven't been. The district didn't play gotcha with $1 million when, in fact, there were strings attached. What the district did was say, we understand things are different than they were represented to us. Compass is working diligently to get that money, and it looks like they could open, even if they don't have it or get it at a later point, waive that condition, and we're still working to...
That's right, you actually waived that condition, right?
Yes, we did.
Okay. Yeah.
And that's actually...
Or you proposed, you waive it or
too.
propose to waive it?
They waived.
We waived it, our board did on December 12th in a resolution, waived it with an explanation. And the explanation was that with an earlier budget that didn't have the $1 million, that budget worked, so even if they never got it, it looked like they could open. One of the problems is that without the $500,000 that they want to use in this current year, coupled with the startup grant, which they have received, you can't use startup grant money for capital improvements. So if you don't get the $1 million, that's one of the reasons we wanted to get that base covered earlier, is to help them. It didn't turn out, so rather than playing gotcha, you can't have a charter, we're continuing to work with them, and we waived that requirement. So I would just say in my closing, because I think I probably have about 30 seconds myself, is that the Poudre board at this point hasn't taken any action that warrants being in front of the state board yet. The charter hasn't been denied, it's been approved. There have been no conditions that have been determined not to be met, and the charter has not been deemed denied. That hasn't happened. This board is working in good faith with the charter applicants. The administration's working in good faith with the charter applicants. And all I'm asking the state board on behalf of Poudre School District is to give us a chance to negotiate a contract with them, the contract that they've had for over a month and haven't responded yet. Thank you.
Thank you very much. So that concludes the oral arguments of this appeal. The board will now deliberate and reach its decision. We may discuss among ourselves any relevant issues in the case. We may not ask of the parties. We may put our counselor on call. So do I have comments, questions? Board Member McClellan.
My concern with the ability to post-approval retroactively pull the pin on the deemed denied grenade might place the charter school in a position where, in a compromised position with respect to their ability to enter into contracts in good faith for facilities, for employees, for anyone else they need to contract with to move forward. And I'm trying to reconcile that in my mind, and it would be helpful. We've heard two different stories about whether or not this language is atypical, but if they're left in a position where entering into a contract for facilities, for example, is contingent on the hope that the board won't yank the approval out from under them suddenly before they can open, I'm not sure how they move forward to contract for the services that they can't open without. So I might need some guidance from our legal counsel to help me get a handle on whether or not that does represent a violation of the Charter School Act. So
Counselor?
I'll let everybody think about that, but that's a concern that's rising in my mind.
Well, and if we get into, really detailed legal advice, I'd recommend we return to executive session. But I do think it's fair to say, at this point, the statute anticipates that once there's an application, that there be a final action on it within 90 days. So,
Final, that word resonates with me all of a sudden.
So I would certainly be concerned about anything that sort of allowed for a retroactive denial of the application that's outside that period. Now, I know there is language in the rules permitting pre-opening conditions. That language is in the rule regarding the contents of charter contracts. It's not in the rule regarding applications. So certainly in a charter contract, for example, we could say we've got to have a certificate of occupancy, a safe and secure facility, and if you get to that day and you don't have a CO and you've got a fire trap of a building, a violation of a pre-opening condition, then the school doesn't open. It's not that the charter gets retroactively denied, and then you sort of have your contractual remedies, and if it relates to health, safety, or legal requirements, there doesn't have to be quite as intensive a remediation, at least per board rule. It anticipates that but if it otherwise doesn't trigger a health, safety, or legal requirement emergency, that there be notice and an opportunity to remediate. And most charter contracts have language in it of the kind that one of the lawyers described, and I can't remember who, but talking about a sort of a 7-day cure period or similar language like that. That was probably more than you asked, but.
No.
Just to confirm my understanding, that language would not indicate that retroactive deemed denied. That would be language more along the lines of shall be deemed in violation of the contract and will have to cure by the following requirements.
Right, you'd go back to the terms of the contract.
Okay, thank you.
Other comments, folks? Guess I will talk a little bit about my concern about the governance. I did read the record. Got confused how many board members you actually have, because there are 12 people there listed, but I guess some of them are not.
That was the founding board.
That was the founding board. Yeah. And to me, at least, there's a difference between the founding board, which for a year or two is going to be based on the founders, based on
it's the disadvantage of
the initial goals of opening, and then subsequent board membership. And I don't have a problem really with you in your record, you look at people who are in charge of finance, facilities, community partnership, et cetera. I don't have any problem with the notion that we would seek board members that bring particular skills and expertise to the board. My concern is that there's only one board member chosen by the families, by the community of the school. And so I'm inclined to agree with the request of the Poudre board, which is that more than half are elected. That does not mean that they are parents necessarily. That does not mean that as a board and as a school that you wouldn't set certain expectations. In fact, I think you're very wise to do that in order to bring in some expertise that is really necessary for a functioning board, because the task you're taking on is actually a pretty big task, right? There's the financial understanding that you need to have. There's the curriculum goals that you have, et cetera. But I do have some concern. This is a public school, and I don't know how you're accountable to your community if they have no way other than leaving your school. And I'm sorry, I only get to talk to you. Sorry. That's just our rule. Do you understand what I'm saying?
Yes.
I think it's important that the parents have some kind of a sense of strength, so that when they enroll their children in your school, they really feel like they're a part of that school and that they have a voice other than just one person that they get to pick. Not diminishing the role that you're playing to begin with, but after some period of time, I think the voting should be broader. And I think at that point, you might even find as a board that there's some expertise that you haven't identified in your, I think there'll be some changes over time, but I think the expectation from the Poudre board that the parents have a stronger voice in electing the board is a really valid one, and I support that.
And I also think that they should have a budget, and I think, how can it be approved without a budget? But first of all, I think you guys need to just sit down with them and negotiate. Just that sentence or whatever, that scares you. But, it shouldn't scare you. That's what I don't know, I'm just thinking of all the contracts that I have signed, and this is going to be due at this point, and this is going to be due at this point, and this point. That's what all budgets are about. Contracts with the feds about research or whatever. You have to have that. And so I just don't see how this is different than any other contract. And
Are you ready for a motion, please?
Madam Chair.
Sorry, Mr. Durham.
I just think I would simply on the board makeup, I personally, I would hope that the Poudre board wouldn't substitute its judgment for what the founders think is a good idea, but should they decide to do that, the nomination process can usually control the election, and so there's a lot of ways to skin that cat if you all are, if we happen to be on the wrong side of that vote. But I think presuming for a moment that we can count on the Poudre board to act in good faith, which I hope is true, and presuming for a moment that fortunately too many boards can be manipulated by staff, that we will also have a staff that acts in good faith, presuming that that's the case, it would appear that we should be able to, that they should be able to get past most of this, but I do think essentially what is condition precedent language maybe it's not precedent, it's actually a retroactive denial, does make negotiation of basic things and nailing down grants, and it even makes the department staff a little nervous about spending federal funds because if for some reason at the last minute it's deemed denied, we're not going to look very good either. It's not just that you've created a problem, you may have created a problem for future grant applications for us. So that, I think, language is problematic, and one would hope in the spirit of compromise that we might get past that language and get on to some reasonable negotiations. I look at these, and an appropriate facility generally is governed by a certificate of occupancy that covers, allows so many people. That ought to be simple. A legally compliant employee handbook, I never get very concerned about that. I think for 17 years I worked for a company that in 1973 or 4 Time magazine called the largest organization in the world without an organization chart, let alone a handbook. I don't get hung up on those details perhaps as much as most people. No fewer than 10 business internships. If it turns out to be 9, the school may still be viable. One would hope we wouldn't get hung up on that level of prescription. There just seems to be too much prescription in these, and Show Roll, fewer than 140 students. They have 138, might make it over the hump. So I would hope we would get there, but I think that in making our decision, we cannot rely, and in terms of precedent that I think that some are concerned about, not all boards and not all administrations do act in good faith. And there are those that set out to try and deny or slow play or in other ways try to limit charter schools. And we have to be mindful that while we have every reason to believe you'll act in good faith, we have also every reason to believe that we will have occasions where people are not acting in good faith, and we need to try and set a standard that takes out of our equation the good faith question, because it will come and go, and the standard that this board sets would be one that would fit either circumstance. So I would hope in the individual approvals and subsequent negotiations we could get to some reasonable resolution. Thank you, Madam Chair.
Board Member Rankin?
First of all, I want to thank our guests for being here today. Sometimes we don't always treat them like guests, but thank you, and thank you for coming and all the work you've put into this proposal. And with that, I move that the board find the resolution condition number 2 to the extent it impairs the ability to finalize a charter contract is contrary to the best interests of the pupil, school district, or community. In the negotiated charter contract, the district may require that the applicant have unconditional possession of the funds as a condition of opening, but not as a condition of finalizing the charter contract. I move that the board find the resolution condition number 3F, requiring that a majority of the applicant's board be elected by parents or guardians of students after 2 years, is not contrary to the best interest of the pupils, school district, or community. With regard to the remaining issues in the appeal, I move to grant the appeal as follows. The board finds that the district may impose pre-opening conditions in a charter contract. The applicant has indicated that it does not object to the following conditions, and thus they are not unilateral and may be reflected in the parties' negotiated charter contract. Number 1, resolution condition number 4 and 8, regarding the need to lease or purchase an appropriate property. Resolution condition number 5, regarding the need to prepare an employee handbook that aligns with commitments made in the charter application. Number 3, resolution condition number 6, regarding the need to secure at least 10 agreements with local businesses for internship placement. Number 4, resolution condition number 7, regarding the need to have at least 140 enrolled students. And the last one, resolution condition number 9, regarding the need to submit an economically viable revised budget.
Thank you, Board Member Rankin. Is there a second?
Second.
Thank you. Further comments?
I'm a little concerned, where are we dealing with the deemed denied?
I don't know why that's there.
I didn't read that.
We didn't read that.
I didn't read that.
We didn't read that.
We're not addressing that in this,
That's not
Sorry.
part of the motion.
Where? Pam?
so we're not addressing that
You're
at
talking
all?
about the title?
Huh?
In the title, this is not a regular charter school hearing.
I'm
and
talking
so-
about the provision that says deemed denied.
No.
Well,
It has all these
we
resolutions
say
that
that
they
the
have to
board
do.
finds that the district may impose pre-opening conditions in a charter contract.
I think it's implied
So it's
that
implied.
that a deemed denied is not a
Is null and
condition
void.
that can be in a charter contract.
Thank you.
Call the vote. Are you ready? Board Member Cloud?
Oh, 1 second.
Sure.
Oh, I just wanted to be understood that these resolutions must be met by CCCS. Okay.
During the contract.
And
Ms. Cordial, could you call the roll, please?
Board
Oh,
Member
I'm
Durham.
sorry. No, yeah. We ready?
Board Member
Please.
Durham.
Yes.
Board Member Flores.
yes,
Board Member Goff.
Yes.
Board Member Masnack.
Yes.
Board Member McClellan.
Yes.
Board Member Rankin.
Yes.
Board Member Schroeder.
Yes.
The motion passes
Motion
7-0.
passes 7-0. Thank you, folks, very, very much. And best wishes to all of you. Break, maybe? Quick break? I hate to say how many minutes because I know you're not gonna. We're gonna be getting. Let's see, if I said 3 minutes, it would be 5. No, it doesn't work out that way.